We went through as much of it as we could and saw how completely unfair this process was. We object publicly and loudly as we can on behalf of Michael Brown Jr.'s family that this process is broken.
By now, most everyone has absorbed the first interview with Darren Wilson, the soon-to-be former police officer in Ferguson, Missouri, who shot and killed Michael Brown in what he and others call an act of self-defense while performing his duties. Granted, there are plenty who will take umbrage with that statement. But the grand jury heard the evidence and has spoken clearly. What is not so clear, of course, are the various incorrect assumptions and opinions about what we take into the stage of ensuring this never happens again. It's a tough job, but let's welcome to MidPoint one more than up to the task. From the Philadelphia law firm of O'Brien and Ryan and the MidPoint legal eagle, if you will, Heather Hansen joins us again from New York. Heather, thanks for joining us, and I'm glad you made it through the weather.
Me too. It is nasty out there, but I'm happy to be here.
Always good as long as you're not snowed in. Let's get right to what Benjamin Crump said, the attorney there. Unfair is the word we're hearing. We're also hearing that after hearing what the grand jury heard, hearing some of the stuff, reading it as well, that there were inconsistencies overall and many things that are still left unsaid and unexamined, if you will. You've had a chance to look at this. From a strict legal opinion, as you look at it, give us your take on what the grand jury said.
The grand jury had so much to look at, Ed. You know, when we talk just in generalities about 70 hours of testimony, 70 days rather, then we start to get sort of dismissive of it. But as I was reading through the thousands of pages, there's so much of it that was boring. There's so much of it, I mean, hundreds of pictures that they were looking at and just being identified. Ultimately, this grand jury heard every word, saw every bit of evidence, and came to a conclusion based on that evidence and the law. So to say that this was unfair really does them a disservice. I have to say that their statements were often preserved for the record, and they were well aware of the fact that people were impatient for their decision and that their decision would be looked at closely. And despite that, they continued to work hard. I'm sure that it was a heart-wrenching decision that they had to make, but they made the appropriate one given the facts and the law.
Heather, let's get down then to Robert McCullough. We just saw a couple of pictures of him, the St. Louis County prosecutor. There are those insisting that simply because he does business with the police every single day, that he was trying to aim this. He was trying to, quote unquote, fix it, if you will, and that he should have called for a special prosecutor. What's your take there?
You know, before this started, I had been asked whether or not they should call for a special prosecutor, and I actually thought it was a good idea because I felt as though every possible opportunity to give some seed to the other side would be helpful in the argument that this was fair. But at some point, you have to stop bending over backwards. The truth is, with this type of case and this type of evidence, had there not been all the media attention, most prosecutors, in my opinion, would not have pursued the case at all. The fact that it went to the grand jury, I think, was to give everyone the idea that all of this evidence would be public, that a jury of the peers would listen to the evidence, and that it would go forward. But McCullough really attempted to put it all out there. The fact that they released this grand jury information the night that the decision was released is unheard of. So all of this was to help support the idea that what they did here was fair. I think, Ed, ultimately, no matter what they did, whether there was a special prosecutor, whether this went to trial and there was an innocent verdict, no matter what happened, there would be some who would claim that the process was unfair.
Let me repeat that before we take a break. 20 seconds left here. Then you feel that if this had gone to a standard jury trial, that the results would be the same looking at the evidence?
Absolutely.
And that's what many people are saying, that perhaps if there had been cross-examination, it might have brought up other things. But aren't we then just looking at theatrics?
Well, and the reality is the grand jurors they have the opportunity to ask questions. Their questions were in many ways cross-examination. They were wonderful, telling, pointed questions that got a lot of the answers that cross-examination would get.
All right, now stand by. We'll return for another time with legal expert Heather Hansen. More on what we now know from the Ferguson grand jury, what questions remain, but also what about future trials? This is MidPoint, where every day we question everything.